If you're involved in litigation and your opponents get caught out in an attempt to pervert the course of justice, do they get into any bother? Well, not necessarily, you may be surprised to find. I know I was. But what's brought this on? It's a recent defamation case. Now, this is the case brought by Noel Clarke. You remember him? He was in Doctor Who and a few other things. He's in a really good film about the SAS, although you can clearly tell they just ran out of money before they got to the end. But anyway, he has been accused of certain Me Too type things by numerous ladies. And that's all been reported in the press. And he is very aggrieved about that. So he's issued a defamation claim. And this week he attempted to get the defences struck out because the newspapers have pleaded. They said, well, first of all, it's true, but in the alternative, we are reporting on a matter of public interest. And as I've said before, with a public interest defence, you don't necessarily have to show that what you're saying is true. You just have to say, first of all, this is a matter that's in the public interest to report on, and clearly allegations of this sort are, but also it was in the public interest to report on the allegations in the way you did. Now, we used to have this thing called the Reynolds defence, which has officially been abolished by the 2013 Defamation Act. It actually says the common law defence known as the Reynolds defence is abolished. And there've also been some case law saying, and don't try sneaking it back in as a checklist. So of course we've all snuck it back in as a checklist. But that would set out things like, have you given the person a right to reply? How many sources have you checked with? How much have you checked this is true? Have you asked around? So they've put forward, like I say, their defences of truth and public interest. But what he said is, well, you have failed in your disclosure obligations. And not just you've failed, you have deliberately refused to comply with them. And he was even suggesting that they may have forged some material, although it's a very weird argument. He's saying, you have, we're trying to hide this material, also it's a forgery. And the court said, well, hang on, make your mind up. If they're going to forge material, they'd want it in. But why was he saying this? Well, first of all, let me explain about disclosure. When litigation is underway, each side has to go through the disclosure exercise where they will say, right, here's all the material I have pertaining to this case. Here's a list of it. And they can say, here's material we have. Here's material we used to have but no longer do for whatever reason. And here's material we have, but we're saying you're not getting it because it's privileged in some way. In this particular case, they're saying it's litigation privilege. So where you communicate with somebody, usually lawyers, but it doesn't always have to be, when proceedings are underway or contemplated. So if you seek advice from your lawyers or you discuss how to defend or bring a claim, that's all legally privileged and it doesn't have to be disclosed. So what happened here? Well, they sought disclosure of certain WhatsApp chats and texts and things like that discussing the case. But there was certain material that they just didn't disclose. Some of it they admitted they had meant to disclose, but there was an accident where they'd clicked the wrong button and sort of gone, this is privileged. So there was one page out of an 18-page transcript, but the judge said, well, these things happen, I'm pretty certain that wasn't a deliberate thing. But when does the disclosure obligation arise, first of all? Well, it arises whenever litigation is contemplated, up until the time you know you are being sued or you're about to sue. You're under no duty whatsoever to keep onto material. I mean, it might be that you have an automatic delete everything after 30 days, or with WhatsApp, delete everything, immediately. And you are perfectly entitled to do that. However, once litigation is contemplated, then you have a duty to preserve this. So what's the definition of contemplated? Well, the courts have said it's not just that it might happen, it's got to be slightly beyond that. So it could be when, for instance, you get a letter of claim. Now, clearly, once you get a letter of claim, somebody sets out the formal thing under the what's called the pre-action protocol saying, we're going to sue you unless you do, you put this right, but here's what our case would be, then clearly it is. But what if you've just been chatting and umming and ahhing about suing each other? Well, in this case, they said it's not enough, because he had actually sent a letter saying, effectively a cease and desist letter. And now they're saying, well, once you got the cease and desist letter, that should have put you on notice that we were going to sue you. But the court said, well, no, you just basically just said, please, take this material down. And yes, we're saying it's not true, but you never actually said you would sue. You just said you would reserve all your rights and you would reserve the right to sue. But you didn't actually explicitly say, and if you don't do this, we will sue. So they said, up until that point, the disclosure obligation had not been triggered. So anything before that time, they were perfectly entitled to dispose of. But once once proceedings are afoot, then yes, you do have to keep this material and you do have to disclose it. But what happened here? Well, like I said, some material wasn't disclosed. Now, to cut to the chase, the court in this instance said it wasn't deliberate. They have now disclosed everything they were meant to disclose. I mean, like I say, there were 3 WhatsApp transcripts that weren't initially disclosed, but they said we'd always intended to disclose them. We just, like on our own system, we just clicked the wrong button. But you have them now. So the court said, well, now that it's all been disclosed, the strikeout application falls away because you can't do them on they've failed with their disclosure obligations. But they went higher, and they were saying this was an attempt to pervert the course of justice. They were deliberately not disclosing this, and they were putting things like they wiped out one WhatsApp sort of chat, but then they did another, and they specifically said, this is in contemplation of litigation. We need to sort out how we're going to run this case. So I said, well, that's legally privileged anyway. But let's say the court did go on to examine this, and they said, well, let's assume that they had deliberately attempted to pervert the course of justice. Would that be enough to strike out the claim? And what's interesting is they said no. They said it's a 2-part test. And what's interesting is they adopted an Australian case from Victoria. And not only did they say, because foreign judgments are not binding on English courts, they are merely persuasive. You can say, well, here's a judgment where somebody's considered the same argument, they've had all this, and this is what the other court said, and we think that's a good way of dealing with it. But in this particular case, they said not only do we find this a persuasive authority, we are actually going to adopt it as part of English law. So now that Victoria case, not Victorian, it was quite recent, but it was in Victorian Australia. Australia's weird, and we've had this discussion before with their 400 different legal systems that they've all got over there. But they said we're adopting this. So what's the 2-part test? They said, well, it's not merely enough to show that somebody was attempting to pervert the course of justice. You would have to show that a fair trial is no longer possible. Because they said, we don't use the strikeout procedure to punish people. At the end of the day, it's all about justice. If you've got a good claim or a good defence, you should be allowed to run it. And if you get caught out doing something hooky, unless now a fair trial is no longer possible, we're not just going to strike out to punish you. Now, I have to say there have been some cases in the past where they have actually said, it did seem that they were saying, you've done something dodgy, you're no longer allowed to defend this case. We strike out your defence. I mean, it'd still be up to the claimant to prove their case, but you wouldn't actually, and you could challenge it and cross-examine, but you wouldn't be allowed to put any evidence in yourself to undermine that. Because like I say, this was an area that, until they adopted the Victoria case, it was a little bit ambiguous. There was a very interesting case, that is Van Hoogstraten, the sort of Rackmanesque landlord. He was involved in some litigation, and he had his opposing witnesses, he had them M-worded. And obviously the other side said, we think we should strike out his defence because he's had our key witnesses taken out. Sorry, I shouldn't really laugh about that, should I? I just like the chutzpah of it. Because it was accepted he had murdered them. He was out of the country at the time, so they couldn't do anything about it because he was living in Rhodesia. But in that particular case, they said, bumping off your opposing witnesses, that is a ground for striking out your defence. Although I suppose arguably because that had made a fair trial impossible, because it's no longer could their witnesses come along. But now it's saying unless you can explicitly show that you can no longer have a fair trial, we just get on with it. Now that's not to say there wouldn't be some sanction, because when it comes to costs, you are allowed to take into account the conduct of the litigation. And that would include things like deliberately not disclosing, putting in false evidence, having your opponents removed, let's hope an accident happens to them and things like that. So these are the sorts of things to contemplate. But yeah, so it's a very interesting one. And like I say, that has effectively I won't say, well, because by definition judges do not make new law, they merely discover the law and interpret the law. So as far as the courts are concerned, it's like, well, this has always been the test, we just didn't realise it before. So yeah, his application to strike out the defences has failed, and now they say, well, let's just go to trial on this. Now it may well be, because apparently they're going to produce they've got 34 witnesses, the newspapers. They're going to call 32 of them and put 2 in by hearsay notice. So that's a lot of people coming along to say, yes, he did this. Although apparently he has 18 witnesses himself. So this is going to be quite a long and lengthy trial. If it goes to trial, of course, because, like I say, there's a lot of preliminary type hearings and skirmishing, especially in defamation. And sometimes, you know, the writing's on the wall. But in this particular case, I mean, it's always, you know, it's one of those things where I always say, never sue for defamation unless you've got nothing to lose. But apparently, you know, this has ruined his career. He's pretty much unemployable. So I suppose this is the situation where it can't get any worse. Interestingly, when his damages claim is for £10 million, because he's not just claiming the general damages, this is hurtful for me and this has ruined my reputation and I need a sum of money to show that this was all untrue and to restore my reputation so I can point to it and say I have been vindicated, look at that big payout, and also to make you feel better, because that's the whole point of damages. It's meant to put you into the place as if the wrongdoing had never happened. So it's like, yes, you've been defamed, but here's £50,000-80,000. You know, you're probably not bothered about being defamed. But he's also claimed special damages, and special damages is where, you know, effectively you can prove, you know, losses, direct losses. So he will be no doubt putting in evidence saying, this is how much I was earning before, now all my work's gone away, so this is what I've lost. You know, effectively, my career is over now, and I think £10 million, you know, is what I would have earned over the course of that if it was all invested. Because like I say, when it comes to damages, we tend to just award like one-off lump sums. So if it's an ongoing thing, we will sort of say, we'll do a calculation. Well, you know, you would have worked till you were 65, or you would have lived till you were 80, you know, get all the actuaries out to sort of try and establish this. So therefore, you should get a sum of £1,000 a month or £1,000 a week or whatever. So we'll do the calculations and say, here's a lump sum. If you stick it in some, you know, savings bank and everything, you'll be able to draw down, you know, on the interest. Eventually it'll draw down the capital sum, and the theory is by the time you get to zero in your bank account, you should snuff it or retire if it was like a loss of earnings thing. So that's what he's put in here. Now what's interesting is the judge has said, well look, let's just have a trial on liability first. Before we get into damages, let's see if you can actually prove your claim in the first place. So there's a bit of a judicial case management there. I mean, it's not uncommon to have split trials. We'll quite often have trials on, where we'll separate liability and quantum, as we say. So, you know, in a road traffic accident, it's like, we accept you suffered those injuries when I ran my car into you. So we accept that, but we say we're not liable anyway because you just walked out in front of us. So you just have a trial on liability. Or it might be the other way around. Yeah, we accept that we did run you over. However, basically we don't accept that that's the amount of loss. You know, we think you're malingering, or we think you're over-egging it, or we think you're claiming for things that you're not entitled to claim for. So we'll accept liability, but let's have a trial on damages. Sometimes you might say we don't accept liability, and we also don't accept that that's how much you've lost anyway. But then again, you can split it into 2 trials. Sometimes judges will say, well, actually, it would probably make sense to just do it all together, especially if it's a relatively straightforward thing, because you don't want to be repeating evidence in the split trials. You don't want, like, well, here's all the witnesses to show liability, and now here's all the same witnesses to show what the losses were. Sometimes it just makes sense to have them all in one go. But in this particular case, I think the judge has looked at this and gone, we've got a 40 witness case here, and court time is very precious. There's no point listing it for another 3 weeks at the end just to discuss liability, quantum, and to get people to put all the evidence in and get the accountants if he fails at the first hurdle and doesn't prove his claim. But yeah, I must confess, I found that a bit surprising, because, like I say, it's not uncommon for judges to penalise parties through, you can either strike out the entire case, you brought this claim, you've done something dodgy, we're striking out your claim, or you're defending this claim, you've done something dodgy with striking out your entire defence. Sometimes though it can be things like, we're not striking out the claim or the defence, but we're striking out, you're not allowed to call these witnesses. You know, you served their witnesses statements too late, you didn't comply with the relevant orders saying, you know, with the timetables and stuff, so you got those in late. You can still have the trial, but you're not calling those witnesses, you know, that sort of thing, and that's the sanction. And like I say, at the end as well, when it comes to considering costs, you know, it could well be, let's say the newspapers, I mean, like I say, the court has actually explicitly found they did nothing wrong, but let's say the court said, actually you did do something wrong, but we can still have a fair trial. It might be, well, when we get to the end of it, even if you successfully defend this trial, you're not getting your costs or something like that. But there you go. As always, hope you found that vaguely useful, vaguely informative, vaguely interesting. And finally, I'm out and about. It stopped siling it down for 3 minutes. So I'm in Truro, next to a viaduct I like. And I don't know if you'll see very carefully, there's actually 2 viaducts there. I've mentioned this before, but when Brunel built the railway, the shareholder said, just get it up quick. And he said, well, you know, trains are going to get bigger and heavier, so we need to plan ahead. And they said, no, forget planning ahead. Trains aren't big and heavy at the moment. Get some temporary viaducts up. So they've got the stone pillars, but the top bit was all wood. And they said, that'll do for now, get some cash in, and then if trains ever do get bigger, then we'll build another viaduct. And that's why, all down in Cornwall, we've got like 20 examples of this, where you've got the old viaduct with the stone pillars next to the brand new, shiny, all-stone viaduct. Interestingly though, you can tell the different gauges, because the original viaducts were on that, and I've got to get this right, because all the railway enthusiasts point out, I think the gauge was 8.25 inch, the original Brunel gauge, as opposed to what we now use, which is, I think, is it 4 feet 8.25 inches or something like that. I did say, well, why do you also have the 1/4 inch? And they said, oh, that's to, you know, take into account the flanges on the wheels and things like that. So, well, why didn't you just make the axles 1/4 inch shorter, and it would have all still worked out. But there you go, that's why I'm not a railway engineer.